name is Elizabeth Ruzich. I work at a law firm. In Salt Lake City. I'm a 7th-year attorney. 95% of what I work on is software patents, but about 5% hardware. So electronic paper displays, lots of social networking, image recognition, databases, any of that. So today I want to talk about the 3 different areas of intellectual property. There are trademarks, copyright, and patents. Since we're talking about mobile developers, I'm trying to focus on making this efficient for you, and it's kind of a cost-prohibitive area, so I'm trying to focus on how we can reduce costs in particular. So let's start with trademarks. So trademarks are defined as an indication of source. They are tied to a good or a service. They're extremely valuable, so the most valuable trademark in the world is Coca-Cola. Trademarks are also associated with a particular good or service. So if I was looking up the different trademarks that have been obtained for Coca-Cola, and actually they're huge. They're kind of in every area you could even imagine. You know, there's the one that we all expect, the non-alcoholic beverages, namely soft drinks. But they also had one for cookie jars, snow globes, playing cards, Christmas stockings, Christmas tree decorations. That one was more about, have you ever seen that Santa that is on the Coca-Cola can? I think that's what they were going for. It had a picture of that jolly guy. They also have Coca-Cola trademark for lip balm, board games. It went on and on. So it gives you an idea. What you do with a trademark is you're filing it in these different classes of goods and services. And so Coca-Cola has a lot of money, so they did it in all these different areas. I'll talk about for you guys. You're better off just going in. There are 2 main classes for software that are good. So in terms of what you're going to consider for selecting a mark, you need to focus on whether you think there's going to be a likelihood of confusion with other marks. So focus on products that are in the same area. So for example, if you wanted to use the term Skittles with a Z, that's going to be a really bad idea if you're talking about candy, because Skittles is a very well-known mark. There's going to be this likelihood of confusion. The test is whether people think they were made by the same manufacturer. So in this case, that would be obvious. But if you were using Skittles for software, then there's not really going to be any kind of confusion because Skittles isn't in that area. So in terms of picking your mark, there needs to be this careful balance between having a strong mark and a helpful term for a product. So, you know, it's great when you are the manufacturer of Skittles and you're just taking this arbitrary mark, which means absolutely nothing, and you're using it, but it can be a little bit more difficult when you're starting out in the world because you want something that kind of suggests what your product actually is. However, that makes it weaker for trademarks, so we try to have this balance. So there are these different levels of trademarks. It goes from arbitrary or fanciful to generic. So you ideally want to select a mark that is arbitrary, fanciful, or suggestive, or else it can't even be trademarked. So let's start with arbitrary. Arbitrary means words in common linguistic use, but when used to identify particular goods or services, do not suggest or describe a significant ingredient, quality, or characteristic of the goods or services. So Apple computer, it's a word we know about apples. It had nothing to do with computers at the time. It did have to do with music, but that was a different area and has a long, complicated history. Next, we have fanciful. Fanciful is a term that's been invented for the sole purpose of functioning as a trademark or service mark. So Pepsi has no real meaning in the world. And by the way, if you guys have any questions, I find it's a lot more of an interesting talk if we can have kind of a back and forth. You don't necessarily want to listen to me the whole time, so feel free. Okay, so next on the level is suggestive. When applied to goods or services at issue, require imagination, thought, or perception to reach a conclusion as to the nature of those goods or services. So this is probably more like the sweet spot that you'd actually be looking for in terms of naming your software. So one good example would be Jaguar for an automobile. Jaguars are fast creatures. The Jaguar car is a fast car. And in getting to the more problematic ones, we have descriptive. Descriptive can't even be trademarked. So there's this kind of special category where if you have it in use for 5 years, you can get onto this common registry. It's kind of a pain and it's a really weak mark, so I wouldn't suggest going that route, but you can. Examples of descriptive are things that are describing an ingredient, quality, characteristic, function, feature, purpose, or use of specified goods or services. So quick print was held to be merely descriptive of printing services. Bed and breakfast registry was held merely descriptive of loading reservation services, lodging reservation services, and apple pie was held merely descriptive of potpourri. Generic is for terms that the relevant purchasing public understands primarily as the common or class name for the goods or services. Escalator is now the generic term for moving stairs. And we'll talk a little bit about this later, but this actually becomes a problem with if your mark is so popular for what you're using it for, it can actually become generic. So escalator used to be a trademark. It was a trademark for moving stairs. Now everyone just uses the term escalator. So once you get your mark, it's important to police it. So why are we even filing a trademark? The benefit of it is that the public notice, it creates public notice of your claim of ownership of the mark. Otherwise, you're only protected where your mark is reached. For example, if you had a physical product like food, it's only the stores that are selling your product. It has to have people who are actually coming into contact with it. It's a little bit less important when we're talking about software because if you have a website, then you've probably reached people in a variety of different states because they loaded the browser in their state and therefore you have this contact. But it's still just a lot easier if you file it. It's not actually terribly expensive. I think at our firm it's about $3,000 from the beginning until the end to obtain your trademark, so it's not that bad, especially once we talk about patents. Patents are crazy expensive. So, more reasons. It gives you the legal presumption of your ownership of the mark and your exclusive right to use the mark nationwide on or in connection with the goods or services listed in the registration. And it gives you the ability to bring an action concerning the mark in federal court. So a lot of this is just legal terminology to say you file your trademark with the Patent and Trademark Office. It's a federal registration. It gives notice to everyone that you filed your mark. So you no longer have to be concerned about this idea of who did you actually come in contact with a particular state. Everyone in the United States knows that you filed the mark. There are two kinds of trademarks. There's intent to use and already in use. Intent to use, if you can do it, is going to be the better way to go. So this is when you're not actually using the mark in commerce. You just have this idea, you want to see if you can get it trademarked. That's going to be a lot better than having already used the mark, then trying to file for it, and if you can't get the trademark, then you have to say, do I want to rename my product? That can be a huge issue. So in order to have the intent to use, you do have to have a bona fide intent to use the mark. You're just signing a form to say that, and generally if you're spending money on it, then you probably do intend to use it. Once you get the trademark, then you have, I think it's 2 years, it's this period of 6 months that you can keep extending with a little bit of money in order to prove use in commerce. So use in commerce is just, for purposes of what you're doing, it would be the download of your software. It has to be, within commerce, which is between states. So if you're selling your product in Utah and someone is downloading it in California, then boom, you have that. You just have to give the patent office a receipt of purchase as proof. So in terms of how to file your trademark application, you need to determine which classes of goods and or services you want to register. So the good is the physical aspect, the service is the services that you're providing related to the mark. So in terms of software, the most common classes that you're going to be using are 9 and 42. So class 9 is a good. It covers computers, their peripherals, software, scientific, etc. It's a long class description. Class 42 is the service that covers scientific and technological services and research and design relating thereto, industrial analysis and research services, design and development of computer hardware and software. Then depending, hey.
So where does software as a service fall?
As far as what?
So you have a software product, but you sell it as a service. It's a pretty common business model these days.
Oh, you're talking about SaaS. Yeah. Yeah, so that would be better for 42, definitely, because so with 9, if you weren't actually having people download your software, then you couldn't prove use in commerce for that class. And so 42 would be perfect for that.
But then an app in the App Store would be nice.
You'd probably want to use both because it gets you just greater coverage. And it's about, I think it's $100 per class for the patent and trademark filing fee. So it's not too expensive to get just a little bit more coverage. And then if you want to keep going, there are many other classes you can do. So if you were in the medical industry, that's another class. If it's something relating to food, that's even another class. So you can keep going, but most importantly, try to get 9 if it's downloaded and 42 just in general.
I'm assuming once you file a trademark, is there routine, like a yearly checkup from that?
Does that
make sense?
Yeah, so what happens is you come up with your class description, you file in the Patent and Trademark Office. They will look to see if there are similar marks. If there is any kind of a problem, if they don't like the way that you described your product or they think that there's something out there that's confusing, they write what's called an office action. They come back to you and they say, these are the issues that are preventing you from getting your trademark. You can resolve all those issues and then you eventually get the trademark. You also have to prove use in commerce, so they'll give you a notice of allowance, say you can get the trademark, but you have to prove it. Or if it's already in use, you would have given that evidence at the time you filed it. Then you get your trademark, and I think it's every 2 years. I have it in here later. Every set period of time, you have to continue proving that you're using it in commerce. So trademarks are forever, as long as you can prove use in commerce.
So you have to remember that at least 2 or whatever the time frame.
Yeah, there are all these slight marks along it, like there's a 5 and 9, because I think after 5 years, it's nearly impossible for anyone to contest the mark itself. They could say that you weren't using it in commerce, but in terms of being confusingly similar, once you've been in the market for 5 years, then it's a lot harder for someone to say it's an issue. So in terms of determining what you want to trademark, the 2 most common areas are going to be word marks and logos. So the word mark is the word itself. So in this case, the example is Coca-Cola. So you file it with all of the letters in uppercase, so that way anyone who is using uppercase or lowercase, if you look at the example I have right here with Coca-Cola where the A in the first word is capitalized, that is going to be one that you could prevent people from using. The next example is one where it's all lowercase, but there's also a slight deviation in the way that it's spelled. And then the next one is a combination of both of those. So it's all the capital in the first word, and then the second word with a K instead of a C. So anything where anyone would be confused and think that it's the same person manufacturing both your trademark and the one that you're suing on, that is the test for likelihood of confusion.
This is jumping back a little bit.
Sure.
But in your previous slide that involved Coca-Cola, you set off the trademark for a particular category of goods.
Yeah.
And in the example you had, it was non-alcoholic beverages, specifically
Soft
drinks.
drinks, yeah.
So I realize Coca-Cola is a mega brand. They have special allowances that regular people don't. But in general, would that prevent somebody from using Coca-Cola for all non-alcoholic beverages, or just that specific category of soft drinks, since they said specifically soft drinks?
So because we're talking about Coca-Cola in particular, and because they have so many classes, they could probably prevent you from using it in alcoholic drinks as well. Because there's just this presumption if someone is using the term Coca-Cola, it's probably the Coca-Cola company that's using the term. If it's you and your mark isn't very strong, then it's going to become an argument. And in fact, it's amazing how much subtlety there is in the wine area and the beer area. There's a lot, because there are just so many marks in that area. And so it's all about very subtle variations. Oh, yeah, yeah. It's called TESS. I don't actually have the link here, but if you go to uspto.gov, so the Patent Office does both trademarks and patents. And so if you keep clicking the links for trademarks, you can go to the website where the database is called TESS. You can put in the word that you're searching for, and you can even specify if it's in a particular class. And it will give you things that have been filed and you weren't able to obtain the trademark on, things where they did obtain the trademark. There's a lot of information there. In fact, you can even go in and, like, if you wanted to do all of this yourself and not involve an attorney, one great way to learn about it is to take a famous mark. You can go in and see the prosecution history, so you can see what they filed, what office action came up, what their response was, how they dealt with it, and how they prove use in commerce, and you could learn about it that way. It's a great system.
So if you're have a name for an app that you're going to put out, and no one's trademarked it or filed for anything, but there's other apps maybe on maybe you're doing an iPhone app and someone an Android app has the same name for an app that would do something similar.
Yeah.
How do you proceed from there? Are you okay to kind of use the same name because no one's trademarked it yet, or?
So generally what happens is if someone was already using their mark and you're trying to obtain the same mark with the Federal Registry, they are much more focused on what's already been registered. And so you'll probably be able to get the mark. Then if it winds up being litigated, that's when it comes into play about where the first mark touched. So it might be that you wouldn't be able to use that mark in California, but you would for the rest of the country because they only had these connections with the state of California. Which is why it's good to register it, because you don't want to be that person. Okay, so there's the concept of a word mark, and then there's the logo itself. So in this case, if we're looking at this Coca-Cola logo, what you would be arguing about in terms of likelihood of infringement is that the logo is this particular script. So if someone is using different words, like if they had Google and they were using the same kind of script and it was a red background, then you would say it doesn't matter what the actual letters are, it's the same kind of look. You'll also see there's this concept of trade dress. If you get enough marks, like if you're Apple and you have iPad and iPhone and iTouch, and pretty soon anytime someone sees an I, they're starting to think it's associated with Apple. And so they have a great mark in that respect because it's a lot harder for other people to obtain the I, especially in software, it's really hard. I think McDonald's is another example of that where, when people want to indicate that they're doing something fast, they just put Mc in front of it, Mc drive-through, that means it must be really fast. So they have this really strong mark that way. So if you do want to create a whole suite of products, if you could come up with some kind of term like that and then all of them have that as the root or the end, that would be really useful. So one question that's very common is, how do you want to actually display your mark? There are 3 different ways that we can talk about trademarks. You can use the TM, which all that is saying is that you intend for this particular term to stand out as a trademark, which becomes particularly important if you're using one of those more descriptive terms, because if it's just saying, like the quick print example, normally people, if they saw the word quick print, they would think it was just a description of your product as being a way to print things quickly. But if you had quick with the TM and then the print, then you're saying, no, this is actually the term for my product. So Google uses the TM to say, Google is a trademark. You can use that whether you've registered your mark or not. Once you register your mark, then you can also use SM if you're talking about a service mark, or the R with the circle. And you should only use that if your product is registered. Yeah?
So TM, if you do it before it's registered, apply that to your logo.
Yeah.
I'm assuming there could be ramifications if it's used elsewhere if it's already trademarked. It's possible that the other company could litigate you for using the same name or the same. Does that make sense?
Yeah, I think that could be an issue, but you're probably just as likely to get litigated. I mean, slightly more because you're without question asserting that you're using it as a trademark, and so it is going to indicate to people that it is something you're trying to trademark or you want to have this trademark signate with it. But I think if they have an issue, they'll have it regardless of whether you use the TM. And it's a lot more important that you are saying to people that you want to assert this as your trademark. So once you obtain your trademark, it is very important to avoid using the mark as a verb. So if you're a little bit older, you might have heard people, instead of saying copying, they said, oh, I'm just going to Xerox it. And Xerox is a trademark. So the word that everyone uses now is Google it. Yeah, I'm just going to Google it. But actually, if you're using it as a trademark, you want to say, oh, I'm going to use the Google search engine. I mean, nobody talks like that, but it's important for Google to be trying to police their own mark and to maintain control over it so it doesn't just become the term for any search engine. There are some great examples of terms that started off as being trademarks and that are now genericized as the term for when using your mark makes it become generic. So, as I mentioned earlier, escalator used to be a trademark, cellophane, zipper, thermos, yo-yo, which is actually allowed in some other countries because this is all based on the country that you're in and how it's used, and aspirin. And Teflon's this really interesting one, but they just had good litigators. So for some things, Teflon is generic, but for others, it's not. It's also important, so in terms of being able to keep your trademark, it's always about control. So if you have other people who are manufacturing your product, then you need to make sure that you have a license agreement in place with them where you're making sure that you are maintaining quality control over the product. There's this term called naked licensing, where if it's a license with no ramifications, so it's saying, sure, you can make my product and try to make sure you maintain quality, but there are no repercussions. You know, there's no damages, there's no breach of the contract. Yeah?
So with using it as a verb, what if it's used as a noun for generic things like Kleenex and Band-Aid? Is that still?
Yeah, that's a problem too. So you would want to say Kleenex tissues. You always want it to be an adjective. And Band-Aid, I think it's adhesive is the term. They have this really strange name because they haven't policed it very well. So it actually is kind of genericized, but no one successfully made it generic yet. So I think you're supposed to say like Band-Aid protective adhesive or something. Kind of awkward. So getting back to the naked licensing, if you are giving someone a license without restrictions, then that is a way, if someone wants to get rid of your trademark, they can say you're not maintaining control over the mark, and that would be one of their arguments. So the other important thing to do is to continue to use the mark in commerce, because you have to prove every 5 years not to, and you can take extensions to get to that time period. So all that is really requiring is that you yet again have another receipt that you're providing to people to say it's still something that people are purchasing. It's still something I'm using in commerce. Okay, so that's all I have for the trademarks. So does anyone have any more questions about it? Yeah.
You mentioned that that trademarks are good only for the geography that you use it in, and so you don't want to. One of the advantages of registering is so you don't end up with a trademark in California but not someplace else.
Right.
We all have apps on the App Store, which is worldwide.
Yeah.
By putting it on the App Store, we have worldwide coverage in most cases. What's the advantage of registering it if we are already going to be showing use in pretty much all geographic areas? There's nothing geographic to really defend that, is there?
So, I mean, I would say it just makes your life easier if it winds up getting litigated. It's not terribly expensive, and what you would have to do is actually prove that someone accessed your website with your trademark in every single state. I mean, think of the money associated with that in the litigation. Litigations for trademarks can easily be $500,000, $1 million. So I would just recommend paying the $3,000 up front to not have that be an aspect.
So it's not just that I'm offering it in all the cases, in all the states, but actually someone purchased it in all the states, is what you're saying?
No, just downloaded the website. So the browser is just rendering your website. So you're proving that someone looked at your trademark on their computer. And it's also, if you have trademarked your mark and you've used it in commerce for 5 years, then it becomes a much stronger mark. And so there's a lot of benefits with that too. It's easier to litigate. So when people are litigating the trademark, there are all these ways where they'll say it's not actually a trademark, it's descriptive, it's weak, it has no power. But if you registered your trademark and it's been in use for 5 years, some of those arguments aren't actually available in the litigation. Okay, so copyrights. I don't actually have a lot to say about copyrights because this is one of those areas where I think if you're interested in getting a copyright, you should do it yourself. It's, you don't want to pay me, especially at my hourly rate, to get you the copyright, because all you're really doing is you can go to the copyright website, download a form, write your information in it, and for you guys, you'd probably be providing your source code. It's $35 to do it online. It's just so easy. Yeah, so don't pay me to do it, please. In the whole 7 years that I've been practicing, I did it one time. And, you know, it's fine, it's easy, but you should do it yourself. Yeah?
I've also heard that once anything's created, it's automatically copyrighted.
Yeah, so that's, exactly, yeah. There's, the other aspect of it is if you just put that copyright symbol on something and you put it on your web page, I mean, so for source code, that's probably not going on your web page. So that might be a little bit different of an issue. And I do have a little bit on that Apple and Samsung case, so it doesn't even matter because they're so weak. So you're not really getting very much for it. But if you do want to do it, I mean, you know, there are many ways you can protect yourself, and copyrights can be one area. So you can do that. So just to give you kind of a brief overview of copyrights, it's a form of protection provided by U.S. law to authors of original works of authorships. When a work is published, you can use the copyright symbol on your work, identify the copyright owner, and show the year of first publication. So the example I have here is the copyright symbol, 2013, Jane Doe. The year of first publication is helpful because there's all this subtlety about, you know, if you have a website and it was running for the last 10 years, you probably want it to be 2003 to 2013 because you made changes along the way. And so if you just span that time, if you just had 2013, then you're only claiming from that time period. And so if someone had theirs in the market before then they might win even though yours was out there, but you're not properly attributing it to yourself. Lots of complications, just make sure you have that time span. Yeah? Yeah.
But so what if that changes monthly? You have to resubmit that code every time you make a change?
Yeah, so some people, they'll do it every year just to kind of keep up with the changes. That's probably good enough. Yeah, but you definitely don't want to just do it one time and then, so maybe every version of your software, you know, it's $35, so whatever you feel good about. Publication is defined as distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership or by rental, lease, or lending. You don't need a copyright notice on your work, although failure to use one could lower damages. So I think it's that whole concept of just asserting that you want to use it as a copyright. Okay, so you can register your code very easily. If you guys want to write down this URL, that's where you can find the forms for registering your own copyrights. So just to give you a brief example of why I'm not a huge fan of copyrights, I wanted to talk about the Oracle versus Google copyright case. So the courts found that the Android operating system uses 9 lines of Java code and APIs that came from Oracle. Google infringed the overall structure of software copyrights held by Oracle, but Google didn't violate the copyrights to Java API. And there's this general thought in the industry that it really shouldn't be about the APIs. You shouldn't be able to sue for copyright infringement because all that is you know, the ability to communicate with another computer access and all that. So it's more if you're the example here where you have the operating system using the Java code, because then you're taking someone else's source code and you're using it yourself, as opposed to the information for being able to communicate with other devices. So because we were only talking about 9 lines of Java code, and you know, we're talking about millions of dollars that went into this, Oracle recognized that they weren't even going to get very much for damages. So actually, just to conclude the proceedings, they said, we won't even argue about damages. So this is currently being appealed. So I think it was last November that they were receiving all of their amici briefs. So that's a term, a friend of the court. So it's when other players in the industry are trying to file this document to say, here's how you should really be considering this. So this group of app developers filed this amicus brief explaining that they think the APIs need to stay covered under fair use. And that was what the district court decided, but then the question is whether the appeals court agrees with that. So this is my example of why I don't think copyrights are particularly valuable anyways. What I think you should really be doing is patenting your product. This is the area where I have all of my experience. I've done trademark work. I don't currently do it. It's fun to talk about, but the really interesting part is about patents. Yes?
I just have a quick question on copyrights. I think it's interesting, for example, the Date One app, and there's a lot of mobile apps that are really allowing users to generate content, right? So kind of the end use case. And while I know that copyright can be used to protect the source code and the coding aspect of it, what strategic value can a intellectual property attorney provide as far as the content usage and how users are going to be using that? What should we be thinking about as far as liability or those types of use case scenarios?
So when you say content, are you talking about the user and what they're creating using that product? So,
Or even the app itself is creating content, right?
yeah, I mean, it's creating content, but I think the valuable part of that is actually the ideas that are going into it that you can patent, because copyright is just about, did they use the exact language in the code? Whereas patents is about, were they the first people to have this idea about journaling and using it in a mobile app and all the applications associated with that?
Yeah, I get the coding part, but I guess I'm just thinking the publishing part, right? Because copyrights is traditionally, the software part. Copyrights is a really big part of the publishing industry as well, where technology and publishing are really starting to overlap in a really heavy way. Is there anything as far as developing apps and user agreements that we have to put in place for users and things like that?
I mean, I guess you could put something in there about how people shouldn't be copying other people's exact terms when they're publishing their ideas. I mean, the same way, if you're talking about copyright with a book, someone can't copy the exact language of the book and write their own book. But, I mean, that's kind of another example where copyrights are only helpful for word, because people are always suing where they say, oh, you stole my ideas and you wrote your own book about this. Well, in terms of plots, I mean, if it's, about a girl who gets out from the small city and goes to the big city and goes to college and lives her life, well, everyone's kind of done that. So that's not really going to help you for copyright infringement. It has to be word for word to get any kind of good result. So I guess my answer is I just don't think it's that valuable. So are we good on the copyright section? Can we move on to patents? Okay. All right, so there are 3 different areas of patents that I want to talk about today. Provisional and utility are tightly connected, and then there are design patent applications. So if the question is when you want to patent your idea, I would recommend patenting it as soon as you have a pretty cogent idea. So it used to be in this country that we were a first to invent system. You might have heard about this. The American Invents Act went into force on March 16th, 2013. It changed it from a first to invent to a first to file. So it used to be you had this great idea, you thought about it, you didn't disclose it to anyone, you finally get around to filing your patent application. Maybe it took you 10 years. If you had email exchanges with other people in your company, even if someone actually filed on the same exact idea before you did, you could submit what was called a 131 affidavit, where you're proving that you had the idea first, you had enabled it, you wrote your code, it was working, all of this stuff. Doesn't matter anymore. Now it's just whoever invented it first and filed it first. So this means that really, as soon as you think you have a good idea, you should be filing a patent application on that. And what we'll talk about with provisionals and utilities is a provisional is a relatively cheap way to do that, just to secure your rights without having to worry about the utility application can be very expensive. Yeah.
Are you saying that prior art isn't a way to invalidate a patent anymore?
Oh no, it's certainly a way. I'm saying in terms of getting your patent, always the concept of a patent is whoever invented it first. And it used to be that if we look at the timeline, you would file your patent application. You filed it in 2010. The patent office is finding prior art that was before that time, maybe 2009. And you would say, well, it doesn't matter because I actually invented it in 2008. And then you would prove that you did that. Now, that's no longer an argument. If someone filed before you filed, then you have to change your claims to have an idea they did not disclose. Another consideration for why you would want to be filing right away is that it's not true in this country, but in other countries, if you release your product before you file your patent application, you're giving up your rights to patent in that country. It's not every country, but let's just have this broad sweeping generalization because it's a lot of important countries like the EPO and Japan and Canada and Australia. So, there's even this exception where, if you're talking to people, you're trying to get money, you're trying to get help, you make people sign a non-disclosure agreement, an NDA. That doesn't constitute a public disclosure. However, a lot of people want to get their provisional on file because if the other people took your idea, they filed the patent application first, you can make the argument that they stole your idea, but then kind of like the trademarks we were talking about before, it just becomes yet another hurdle that you have to argue about. So before you even go and talk to anybody about this, I just recommend filing your provisional application. So in the United States, if you did wind up releasing your product and you haven't filed your patent application on it, you do have this 1-year grace period. So you're giving up your foreign rights, but you still have the rights in this country. And that's hugely important, so just consider that you have that grace period. So talking about the difference between provisionals and utilities, a provisional patent application makes sense if you don't have time to write a full patent application, a full utility, or if you want more time to see if the product is worth protecting. So provisional applications aren't actually examined by the patent office. They serve more as a placeholder, and within 1 year of filing your provisional patent application, you need to get your utility application on file. So there's a variety of ways that you'll see what the provisional application looks like. It can just be, if you're working with me and you don't have a lot of money and you just want something on file, sometimes I take your white paper, your design of your application, I just take out certain terms that would be really problematic for litigation. Like if you said it can only work this way, it's absolutely necessary to have these features, then I'm going to take that out and make it more generic and say in one embodiment, for example, kind of soften the language, and then I can file that. And, if that only takes me a couple hours, well, that's not terribly expensive. I do also recommend putting in hardware. So the patent office, not everyone understands technology, so some people don't really grasp what software is, how it interacts with a computer, hardware and signals, and that kind of blows people's minds. So it's a lot easier to get your idea patented if you have a system diagram that's showing a client and a device and a network, saying here are some signals, we download the application on the client device, we communicate with the server, which is doing the remote processing, just something, and some kind of diagram that has a memory and a processor, and we're saying there's actual hardware elements here. Because a couple years ago, they had this case that went up to the Supreme Court called Bilski, and that case said that if you have a method claim that's describing your invention, it has to be tied to a machine or a computer. So if you don't have enough hardware description in your application, then they would say that it's not enabled. The concept of enablement is to say that a person of ordinary skill in the art could practice your invention. So for purposes of what we're talking about, that's another computer programmer. So you have to describe your application sufficiently in order to have other people reproduce it. So I created this little diagram to kind of give you an idea of the timeline too, because one of the other advantages of having the provisional application is that you have that 1 year period before you have to invest all that money in the utility. So that's a nice year where you can see if your product is actually going to make it, if you're going to get enough money that you can pay someone to write the utility, if it just gained no traction and so you can scrap it. I mean, the filing fee for the provisional is only $130 if you're a small entity, which means you employ less than 500 people. Once you're getting to the utility application, it goes up to $500. Once you're talking about, which I'll explain in a minute, the patent cooperation treaty, those are $3,000 at a minimum for the patent office fee. It can be up to $5,000. There's a lot of different factors with it. So I'm just trying to extend the time that you have to pay that much money. So if we look at this timeline here, we have from filing your provisional patent application to obtaining an issued patent. So at 0 months, you're filing your provisional application. Then within 1 year, you're filing that utility patent. That's still talking about the concept of the application in the US. Then the patent cooperation treaty application, that is a placeholder for filing in other countries. So people who have signed the patent cooperation treaty, it's 180 countries. It's generally everyone that you'd be interested in except Taiwan. And that's because China is a member of that country, and there's a little bit of tension about whether Taiwan's a separate country. And basically, China said, we're not going to sign this thing if you let Taiwan be part of it. So if you did want to file in Taiwan, you'd have to do that within 1 year of filing your patent application. For everybody else, you can file this PCT application, and that gives you a much longer time period before you have to elect which countries you want to file in. So you file the patent cooperation treaty at 12 months from the provisional. Then within 30 or 31 months, depending on the country, you're selecting which countries you actually want to file in. And you want that to be as long as possible because it's enormously expensive. So a lot of the countries require that you have a translation of your application up front, and just the translation can cost $10,000. The general process can be easily $50,000 per country to obtain your patent in that country. So you really want to delay those fees if you're interested in filing there. Generally, for the smaller inventors, I say don't worry about it, just file in the United States. If the question is whether you want to take that $50,000 and get a single patent in a single country, or do you want me to write 5 or 10 more applications for you, then it might be a lot more valuable to just protect yourself in the US. So the other thing on this timeline is the patent office, especially with all the financial crisis and budget and government issues, they don't have enough examiners, so it usually takes them a couple years to pick up your application and even start examining it. So similar to the trademark application, you file your utility, you have claims that you think describe your invention. The patent office is going to look at that and say, do I think there's anything similar that's already out there? If they think there is, which 95% of the time they do, they're going to come back and say, you cannot get this patent because of these things that already exist out there. So then as the patent attorney, I take the claims, I narrow them down, I might call the examiner, talk to him about it, I file narrower claims, and we go back and forth. So generally, the entire procedure can take between 3 to 5 years. If you want to speed it up, there are some fees that you can pay in order to do what's called a track 1 filing, which they promise they'll pick up the application within 1 year. But for a small entity, I think that's still $2,500 on top of the $500 for the utility, and that just guarantees a couple rounds with the examiner. It can get expensive really fast, so a lot of people just wait and hope that it'll happen. Okay, so this is everything that I already mentioned. One way that you can speed up the process is, so the examiner is the person at the Patent and Trademark Office who's looking at the patent application. They say that they think the claims are too broad. They send me this office action. I can call them up and kind of get a feel for if they think it's a ridiculous invention, it's never going to get patented, or if it's pretty close and they just need some little tweaks. You know, if you call them, it's generally a lot easier to kind of resolve the process faster, and that's good because it's not just that you pay that fee that one time. You get kind of 2 rounds with the examiner, and then he wants another $500, then 2 more rounds and another, and generally I try to resolve it within 2 to 3 office actions, but for some of my clients who are larger, who really want to get broad claims and they don't want to capitulate and give away anything, I have ones where we're up to like the 8th round now, and that's so expensive. So I'm only going to do that if you're okay with it. So what can you patent? There are 3 main areas in software that you are getting your patents. There's what's called a method. That's the broadest one. There is a system apparatus. That is talking about the software itself being tied to your device. Then there's the computer readable medium or computer program product. That's like your disk, your series of instructions for executing the application. Generally, we file 3 sets of claims to each of those. So 1 method, 1 system, 1 CPP or CRM. So this is an example of a method claim in a patent that I obtained. I'm going to give you an example of what this invention is to kind of give you an idea that it doesn't actually have to be about the hardware itself, or, I mean, it can really be about these very basic concepts. And this idea, it was about if you're on the internet and you want to provide comments on websites, you might have a bunch of different personas. So I think it's a little bit hard to see here, but so this is Sarah Johnson's the user interface for your software, where she's explaining how she wants to write a comment on a web page. So maybe she wants to identify herself as Sarah Johnson, or maybe she has this persona that's called Food Girl. So, you know, she gets really well known as Food Girl, and then people can't track her down, and if she wants to say nasty things, then she doesn't have to put her name out there. So all this is just a GUI with a drop-down for you to select what person you want to identify yourself as for the website. And I filed this patent 3 or 4 years ago, and this is the claim. It's actually a really small claim. A lot of claims these days are over a page. So in terms of the structure of your method, I mentioned that litigation with Bilski. So the way that you're doing this, the way you're structuring your method claim is to say a computer implemented method for doing a thing, comprising, receiving, using the 1 or more computing devices. So that's the part where you're tying it to a machine or an apparatus. So it's receiving information, associating the information with personas, which we talked about is like, do you want to be Food Girl? Are you anonymous? Are you identifying yourself as Sarah? Associating a particular persona of the plurality of personas with the second user on the social network being distinct from the first user. That is, which one was this? I got them 2 patents. So yeah, I think this one was just about how you have 2 different people who can be associated with the same corporation. So you can give them both access to the same persona. So everyone is posting on the social network as the Coca-Cola company, and multiple people might want access to that. So you're receiving a selection from one of the plurality of personas. We don't have to go through the whole thing because I know this just quickly devolves into claim language. It's complicated. It's the sort of thing I would really recommend that you use me for instead of trying to write yourself, because it's really tough unless you've had several years of experience. It took me 3 years before I even felt pretty good about what I was doing. You know, someone was always looking at my stuff until then. So mostly I'm just trying to give you the idea here that a method is a series of steps. So we have receiving, associating, receiving, determining, providing, and then you want to make sure it's tied to that computer. So it could say using 1 or more computing devices, 1 or more processors, something to connect it to hardware. Yes?
So what would you recommend, for example, Paul just presented about day 1. You know that app? It's like a journaling app. You can write about your day or add a photo.
Yeah.
So I mean, something like that, that's like so generic, and there's tons of apps doing it, and he's doing it really well, which is why he was so successful. But if you have an app that's like that, I mean, there's 50 others that existed before, and there's hundreds after.
Right.
Would you even bother going for a patent there, or what would you
Yeah,
recommend?
there's so many things that you could think about in there. So with his application, I probably shouldn't talk about it too much because lawyer and all that, but I would think that certainly the concept of journaling is well known, but maybe some of the social aspects where you're connecting two different people and you have something that's an event between two people, or maybe your GUI is really unique. You know, instead of a drop down, you're doing something that other people don't do within the GUI. Often I make a lot of advancement by talking about the permissions or the visibility. You know, with Prism, everyone is super concerned with how your information is being displayed, or maybe you're encrypting it in a certain way. There's a lot there, so I would just recommend, what I normally do is, I know especially for app developers, we're talking about people who don't have a ton of money, so I will just say, you know, I'll file your provisional $3,000 and I'll do a search. I'll come up with what, you know, I'll find stuff that I think might be problematic so that we're not wasting all your money filing something that never becomes a patent. We can talk about it. I can file the provisional. Then, you know, you're not investing too much money, and that gives you a year to see if your idea is making money to file that utility.
Okay. And the end goal of these patents, is it just to protect yourself, or, I mean, what?
There's so many things. So you might want to protect yourself. Someone says that they're doing it, they sue you, you say, well, you're also doing the same exact thing and I have this patent here, so maybe we should just get cross licenses to allow each person to use the other patent. It's especially when you're talking about hardware, you don't have, for the evaluation of your company when people are looking to buy it, you don't have a lot of physical assets, and so intellectual property can be incredibly valuable. In terms of getting money from VCs, like have you ever watched Shark Tank? They're always saying, do you have any patents on that? Because they want to know that someone else thought it was a valuable idea. So if you can say, well, the patent office thought it was so valuable, I have these patents on it, then VCs are going to be persuaded to give you money. And it just protects yourself. If people are stealing your idea and they're trying to use it themselves, you can force them, you know, if you don't want to pay for the litigation because it's just so expensive, but you can send them, I forget the term for it, but you can send them this letter that says, I just want you to know that I have this patent, and that can stop them from doing it. It's something you should always consult an attorney about, because you don't want it to say, I have this patent, you're doing this thing, and you need to stop right now, because that's what's called a declaratory judgment, where they can then go into court and sue you because they're saying you were going to sue them, and it's so likely that that was going to happen that they're just jumping and doing it first. And it's a careful area, but in any case, you can send these threatening letters to people to make them aware of the fact that you have a patent, and hopefully they'll take the clue from that they need to stop copying your idea. Yes?
So like what, let's say we don't have a patent, we don't have a trademark, we do a ton of outsourcing where we send our code to different programmers, send our art to programmers. Do we have any standing at all if they steal that from us, if we don't have a patent or a trademark? Or what would we do legally then?
Yeah. You know, if you're sending out your code, the copyright probably is a good idea, because then it's just hard, because if they actually took the code and then they modified it, it's harder for you to sue because it's not the exact same thing. But I mean, that would be one way to protect you, and it is not terribly expensive. I think I saw another question too. Okay. So that was a method. Oh, okay, sorry. Just for provisional, a very basic one. So I have a lot of different rates. I can't speak to other people. Almost all of my experience in my 7 years has been in Silicon Valley. So I'm probably a little bit more expensive than people in Utah, because there's not a lot of software attorneys here, a lot of really experienced ones. So I think my average is about $10,000 for utility. That's obviously way too high for you guys. So I tend to just talk to you about it and get it down. Maybe it's $3,000 for the provisional, maybe $5,000 for the utility. I mean, we can work through it, because I also think it's really valuable to help the community out by making things a little bit less for people who are just starting out. Yes?
If we don't have one, do we still have a right to sue someone, or do we give any standing at all
Well, I mean, the other aspect would actually be with contracts. You know, you make someone sign a contract that says they're not going to use the information, and non-disclosure agreement. So then you have a breach of contract claim. That might actually be the cheapest way. Contract attorneys are really cheap, so you could see them. Yes?
Just to clarify, like what I would add to that contract is, I think the contract attorneys are really cheap, but if they aren't aware of intellectual property issues, I think having an intellectual property that can, attorney that can really clarify ownership of ideas is really important, and that's very clear in your agreements. And a lot of just general attorneys don't really understand some of those nuances around how to define ownership, how to really create a clear assignment of ideas. So that's where I'd say like someone like Elizabeth would be very, very helpful to give you that insight, especially if there's anything around ownership of intellectual property.
Yes?
Do you have an opinion on the lawsuits? So they hold certain patents and they've been going after small developers.
The trolls. I'm not a fan of trolls. I don't represent any trolls. In fact, I don't think any of my clients have ever sued anyone for patent infringement unless it was like a countersuit because someone sued them. Some attorneys get kind of a bad reputation for that, for just going after people. So for those of
Protect ourselves
against them.
any insight on that case?
So, you know, your best bet in that case is just to have a group of people that Lotsys is suing everyone who has, you know, an app in the App Store. So if you can combine your lawsuit with other people's, I believe it's actually been hard in that case to do that, but if there's any way you can do that, then it makes it a little bit better because it's just so expensive to go through a lawsuit. So in general, I'm just advocating for having your own patents so you have some leverage when people are trying to do that. And you can, if you can make it equally painful for them, then it becomes a little bit easier. So we are getting close to running out of time, so I'm just gonna fly through a couple of these because I do want to talk about design applications, which is another type of patent application that's much, much cheaper. So this was my system example. We won't go through the claim, but I can give you an idea of, this was a patent that I obtained for a company that, it's for conferencing software, and it's a really cute idea. It's, if you're in a conference and you want to get up and go to the bathroom, or you're just really bored with it, you can have this thing called a ghost profile. So you can pause it so people are still looking at your image, it's just not moving. And so you can maybe trick them into thinking you're still there and you're really active. Or you could put that on and then, you know, you switch your browser and you're doing something else, and yeah. So this patent, I think I got in the last year. So it was filed in 2010. So, you know, you might think that all the ideas should have already been patented, but they really haven't. I mean, the claim is kind of long, you know, it's about a page, but it could be a lot longer. It's certainly possible to get claims for things like that. And this one I have just for fun. This is not mine. This was filed in 1999. This is Apple, and this, so if you're thinking about, you know, I mentioned you can have a GUI that's doing something that's kind of interesting. So in this case, this is the GUI on your toolbar. And it was filed in 1999. Steve Jobs was one of the inventors on this. The idea in this claim is that it's just about hovering your mouse over the toolbar and having the icons you're hovering over be larger than the other icons in the toolbar. Which, sure, today that's crazy, right? I mean, everyone can do that. But back in 1999, that was sufficient to get this patent. So this is just a little bit, we're going to skip over this because it's pretty dry. It's kind of an example of the reason why you want someone like me to write your claims, because it's easy. If you're just trying to do it yourself, there's a lot of pitfalls, and this one's about multi-party claims. You want to make sure it's from one side, it's on the client device or it's on the server device. If you combined both of those, then it makes it harder because you're having to sue more people, and it's not just the direct infringement, it's other kinds. So getting to design applications, these are about the new, original, and ornamental design for an article of manufacture. So this is another example of when GUIs can be kind of valuable. Having GUIs that you're using to identify your your product. So it's most commonly used for shoes. It can also, so in this case, it's, you know, the design of the Nike shoe. It can also be, Porsche has these covers that you can put on the front of their cars. But in one that's much more interesting to you, Apple has a design patent on the way that their little notepad and their calendars look. So this is, you know, those rounded edges that anyone who's read about Steve Jobs and his obsession with rounded edges, he's a design patent on the rounded edges for his calendar. RIM has a design patent for the case holder for their smartphones.
Is that why Microsoft is rounded there?
Yes, it is. Yeah, well, it's a valuable thing to have then, right? Because you can prevent people from having these rounded edges. So here is another example of an Apple patent application for design. This one, so one of the things to consider with the drawings for your design application is things that are dashed are things that aren't necessary. You're just using it to kind of understand, to show what you're looking at in the application. So if you look in this case, the solid lines here, this is just for an iPhone and the slide to unlock part of it. And the dashes that are around it are such that they're saying it doesn't actually have to be on the bottom of your iPhone. It could be up higher, in the middle, or, and then all the stuff about, you know, where is the clock located, that's all optional, which is why it's dashed. It's just to kind of give someone an idea, because if you just had the square with the slide to unlock, people would be like, I don't even know what that is. So anyone can look at this and say, oh, it's for that. You should make sure that you have a lot of different views of what you're looking at. This is the design application for the cover for the iPad that you've probably seen everyone has, the one where it folds up really nicely. So we have, it goes on to this page. So we're talking about 7 different views that they used in order to get the design application. Design applications are, you know, they're kind of weak in what they're actually covering. So here we're looking at, this is one of those, what do they call it, like a nail bed? When you're trying to file your nails, you use it, you know, to file them. I don't know, I'm not girly like that. But in any case, so if we're looking at the prior art here, the accused infringer and the patented design, these are all really subtle differences. One of them is 3-sided instead of 4. The accused infringer had like a buffer on one side instead of the gritty part. It's kind of limited, but I mean, it's still, you know, if, as you can see in ones like the Apple one, it's incredibly valuable. So this is the Apple design where you can see the dashes. This is just on your iPhone having the circle as your home. It's great. They got a ton of applications on it. So all the dashes here to say, you know, the SIM card doesn't actually have to be on the top, it can be somewhere else. But just the concept of having this iPhone with the circle on the bottom, that's pretty great. You know, Samsung really wanted that. And they won in some of these design applications. So it's something to consider. That should be it for me because we're already over. So if you guys have any questions, feel free to come up afterwards.